Hi, everyone, and welcome to episode 19 of the Legal Lunch Byte. And I am delighted to have one of my colleagues joining me today, Elijah Hartman. Elijah, this is fast paced, so no time for pleasantries. But before we get started, tell us a little bit about yourself.
Yeah, so I actually grew up in upstate New York in a little country town. I have a background in music production and composition. I went to the University of Washington for my degree in intellectual property and policy. I'm currently an intellectual property attorney. I do litigation, I do cannabis, and I'm excited to be here talking about copyrights today.
Perfect, and yeah, that's exactly right. We certainly trademarks account for a big part of what I do, and I know that we've had a lot of blog posts and other webinars, different things talking about trademarks, but we haven't really paid that much attention to copyright. So I'm excited to be doing just that. And let's start with the obvious question: what is copyright?
Well, copyright is a legal term of art that's used to identify certain types of protection that is granted to authors or creative of certain types of creative works. So when someone sets out to write a book or a screenplay, what they created, what they typed into their computer or wrote out on a piece of paper, that creation is likely protected under copyright. And it happens actually automatically. So if you've ever written an essay, painted a picture, recorded a song with your phone, or took a photograph, you likely have a copyright in it. And copyrights really come from the Constitution that empowered Congress to promote the progress of science and the useful arts. And so what they did was they created a Copyright Act of 1976 that protects original works of authorships that are fixed in tangible mediums of expression. So what that basically means is from the moment of fixation, the moment you write it down, there's no registration requirement. As long as it's a little original, as long as it's a little creative, you've got a copyright.
And how are copyrights different from trademarks, let's say?
So yeah, copyrights do not extend to slogans, trademarks, words, or phrases. So trademarks are really about use in commerce of a word or a slogan to identify a source of goods. And copyrights are something more creative than that. They're, for example, lyrics, they're a book. So a book could have a trademark in the name of the book, but the actual book itself is protected by copyright. Copyright also doesn't extend to ideas or facts or procedures or concepts, some of the things that are covered by other intellectual property regimes like patent, for example. And copyrights also don't extend to, even though they're creative, they don't extend to what's called scène faire, which is a French term of word that means to set the stage. So these are things that are really needed by other people, and the public benefits them so much that even though they're creative and even though they seem a little original, they're not protected as a copyright. An example would be a scene in a book or a movie that has a beautiful Italian restaurant with candle lights and arts on the walls. That really just sets the stage for the actual protectable aspects of the copyright. And so other people need to use the beautiful restaurant with candle lights and art on the walls in their creative works, so we don't protect that as a copyright. So you're right that trademarks are a little bit different, so are patents, and copyright really applies to things like literary works, musical works, architectural works, sound recordings, motion pictures, and pictorial and graphic and sculptural works.
Just a quick question. Is there a threshold level of quality that a work needs to exhibit before it's subject to copyright protection, or any sort of scribbling on a piece of paper will do it?
Well, there has to be some originality, which means it has to be independently created and originate with the author. But there also must be what's called a low modicum of creativity. The bar is really low. So, for example, phone books are just a recitation of facts. They don't have any creativity, and they don't rise to the level of creativity needed for copyright. So if you just do a little stick figure on a napkin, that probably does not have enough originality and enough creativity to be subject to copyright. It needs to be something more than that, although not much more.
So one concept that we hear about quite a bit in the context of copyrights is fair use. And I've certainly heard what I'm pretty sure are incorrect interpretations of what that is. Often when using material that is protected by copyright, people are very quick to throw out the fair use defense, like, well, it's okay because this is fair use. But I wonder if that's the case. So let's first of all introduce the concept. What is fair use when we're talking about copyrights?
Yeah, so there are, although owners of copyright have certain exclusive rights, like the right to create derivatives or reproductions, there are some instances where you can actually copy someone's copyright or make a copy of it or make a reproduction or create a derivative that are so important to the public that they're deemed to be a fair use. And there's actually statutory definitions of fair use, and then there's the case-by-case evaluation that courts use to determine for everything else to see if you've actually, even though you copied, you're not committing infringement. And some of those fair use, those core fair uses, are for things like criticism, commentary, news reporting, teaching, and scholarship and research. Even things like parody can be a fair use, so meaning you're not infringing on someone's work. But the court really looks at a number of factors and a case-by-case basis for each alleged infringement and alleged fair use defense that's averred.
What if I take a work, a book, and decide that it's a good book, I like it, but it could really use some new characters. I believe that it could be enhanced. First of all, would there be protection for that new work that I've created, and also what are some of the considerations that people should keep in mind if they decide that they want to start playing with existing works, such as in the context of fan fiction?
Yeah, so I mean, if you're the copyright owner, you have one of the exclusive rights to create derivatives. That means to create sequels or prequels or new derivations of the work. But if you're not the copyright owner and you find someone else's work and you really want to extrapolate on it, you want to make it better, you want to create a coffee table book about the movie, or you want to create a trivia fact book, or you want to use an excerpt. We get into the realm of fan fiction where people are creating derivative works that are based on a movie or based on characters, and they're running with the plot and they're running with it. And unfortunately, that technically violates the exclusive rights of the copyright owner to create those derivatives. So what courts really look to on the fair use analysis is whether something is so transformative, so recast, as to be a fair use. So, there are instances where someone made a trivia book, a Harry Potter encyclopedia, or published a guide on a TV show like Seinfeld that were deemed to not be fair uses because they were violating the rights to create derivatives. But there are some other examples of fair use that have been deemed fair use, and an example of that would be using a small part of a song in a theatrical performance. That's been a fair use. If you parody someone, even making a funny song, you make the song a little different, you change the lyrics, like Weird Al Yankovic, that has been a fair use as well. And in the realm of TikTok videos, people routinely, for the purpose of criticism, take an entire video and they mash it up and they create other video elements in it, and they create a parody or a commentary on the original video, and that is also likely a fair use. But even if you've copied an entire paragraph of someone and put it in your own work, that could be a fair use. And there is actually a case where a real estate blog copied an entire paragraph from a news article, and the court said, listen, this doesn't affect the market for the original news article, so it's a fair use.
We sort of going back to this idea of misconceptions that people might have, or maybe not misconceptions, that in some cases it might be true, but we do hear, or at least I hear a lot of this popular wisdom when it comes to how to avoid infringements, and often you hear people say, well, if you use if you're taking a song and it's less than X amount of time, then it's not going to be an issue. Is it really like that, or is there perhaps a little bit more nuance?
Yeah, so right now courts interpret music sampling specifically a little bit differently depending on where you bring the action for infringement. Some courts have said that even using a little bit of a song is enough to constitute infringement, but the analysis really doesn't change. It's still looking at those variety of factors. How much of the work did you use? What was the purpose of your work? Does it interfere with the market in the original work? And those are the types of factors that courts look to. But as a musician myself, I think there's a history of musical borrowing, whether that's creating mashups, that's kind of running on an idea, a musical homage that is necessary in the music industry. The problem is that doesn't always pan out with the courts. But there has been some instances where entire melodies were copied, some of the lyrics were copied, and the court did determine that to be a fair use.
That brings us to a very important question. If you are a creator, what steps can you take to protect your copyright?
Yeah, so the first step to protecting a copyright is to register it with the Copyright Office. And what that does is it allows you to sue for copyright infringement. And in fact, before you bring a copyright infringement case in most situations, you have to have that registered. It doesn't take a long time. It's a pretty simple process. The Copyright Office normally approves most copyright applications. And so that's the first step. It provides notice to people that you have a valid copyright in something and that you intend to protect your work. The other thing that you can do is to work with an intellectual property attorney, and there's also some software out there that can scan the internet and see where your work is being reproduced. If you do see that your creative work has been used by someone else, then in talking to an attorney, you can craft a cease and desist letter or a demand letter, or you can try to negotiate licensing fees after the fact with the alleged infringers, rather than going full speed ahead with copyright infringement litigation, though that is a possibility. And one of the benefits to enforcing your rights in court is that there are statutory damages. And for instances where people have willfully copied a copyright of someone else and willfully committed infringement, that they can get damages for up to $150,000 per instance of willful infringement. And in the internet age, that's a lot of potential infringement. Every time you copy a file into the memory, every time you distribute it or put it on your website, that's an instance of copyright infringement. And that could mean there's a lot of statutory damages to be had when you're seeking to enforce your copyrights. So the first step is to identify situations where your work has been infringed, and then to figure out what legal remedies you're going to use, whether it's trying to get that work taken down from a website, or it's suing for copyright infringement.
Let's look at the flip side of that. If you find that someone is sorry, that's what you do when somebody's infringing. What happens if somebody's accusing you of infringing?
Often in these situations, a quick response is the best response. Silence really doesn't do any benefit to defending from an infringement litigation. But talking with an attorney, evaluating your fair use factors, and seeing if you can negotiate a license agreement in instances of actual infringement. But there are other defenses that can limit those statutory damages, including the innocent infringer defense, and independent creation that you might want to talk with a lawyer about to see if you have as grounds to defend against litigation. But if you're faced with a demand letter or a cease and desist letter, don't ignore it. Contact a lawyer and see what defenses you have to either avoid the litigation or what negotiation and settlement you can reach to resolve the matter.
We are very internationally minded at the firm, so let me ask you to touch very briefly on the international aspects of copyright protection. Do you need to go and register your copyright in all countries where there might be possible infringements, or is there some way perhaps of streamlining the process, as with trademarks, where you can basically take a U.S. application or registration and extend that to other countries through the international registration process? Is there something like that in the copyright realm?
Well, there's not exactly an international database that everyone uses to register their copyrights, but there are some treaties that are on the topic, including the Berne Convention and the TRIPS Treaty, where most countries signed on to provide authors some original form of creation protection for what they've originally created. Now, in the United States, they've taken that one step further and granted protection for life of the author plus 70 years. But most countries recognize that copyrights exist. They have a structure for enforcing copyrights, and it's based on the moment of creation. It's not based on the country of creation. So you should be able to enforce your copyrights in other countries, even though you didn't make the copyright there.
Well, we are almost at time, Elijah, but before we sign off, I just want to give you an opportunity, if there's anything else, some parting thoughts before we sign off.
I think we had a really great discussion. I'd love to follow this up with some more talk in the future about copyrights and what to do. I also think that there's some really interesting distinctions in copyright between rights of publicity and who is the owner of a copyright. So the particular thing I want to mention on closing is just because someone takes your picture does not mean that you own a copyright in that. In fact, in most situations, it's the person who took the picture that holds the copyright. And so it's important to know that when you're agreeing to have your photograph taken, because you might not exactly have rights to stop them from using your picture or your photograph in the future. But we can definitely talk about that as we talk about rights of publicity.
I think that's definitely a topic that we should address, that deserves the full 15 plus minutes. And we've had some very interesting matters. So definitely looking forward to that conversation. For now, first of all, thank you, Elijah, for joining us. And as you suggested, I mean, we are going to be putting together more content regarding copyrights. Look for webinars in the near future. Look for blog posts, etc. And in the meantime, don't hesitate to send an email to Elijah if you have any questions about what we discussed today. So with that, thank you once again, Elijah. Thanks to our audience. Thanks to our producer, and see you next time.